Hi there. This presentation is about Japan Beverages case, and I'm Giuseppe, and I'm gonna start with a brief timeline of the steps occurred from the consultation with the parties to the panel report submission. In a communication of the 22nd July of 1986, the European Communities request consultation with Japan on Japanese custom duties, taxes, and labeling practices on imported wines and alcoholic beverages. In a further communication, the European Community stated that consultation with Japan had not resulted in a satisfactory settlement, and that the Community wished to refer the matter to the contracting parties in accordance with the Article 23, Paragraph 2. Based on this article, if no satisfactory adjustment is effected, the matter may be referred to the contracting parties. The contracting parties shall promptly investigate and make appropriate recommendation. At the Council meeting on the 6 November 1986, the Community requested a panel be established and that, in view of the urgency of obtaining a settlement, the contracting parties apply the urgency procedure. This procedure is provided in the paragraph 20 of the Understanding regarding Notification, Consultation, Dispute Settlement and Surveillance of 1979, and, if applied, it forces the panel to deliver its finding within a 3-month period. On the 4th of February 1997, the Council agreed to establish a panel. At the same Council meeting, the representative of Japan outlined measures proposed by his government as part of the overall reform of Japan's tax system. With regard to the liquor tax, the measures comprised the abolition of the ad valorem tax, the reduction of the specific tax, and the abolition of the grading system for whiskey. The Community had yet to explain the extent to which these new measures were satisfactory. Japan asked the Community to make such an explanation as early as possible. Eventually, the panel submitted its report to the parties on the 22nd of September 1987. The liquor tax law was enacted in Japan in 1940, and it classified alcoholic beverages in 2 categories and set the tax rate on each of them. An ad valorem tax was introduced in 1962 to some of the special grade sake, wines and special grade whiskies, of which the price exceeded a certain threshold. The revenue from the liquor tax was the 3rd most important revenue source after the income tax and corporation tax in 1985. The Japanese liquor tax law classifies liquors into 10 categories. 6 categories are further classified into 13 subcategories, and in the case of sake and whiskey and brandy, into 3 additional grades. Ad valorem taxes are applied on special grade sake, special 1st and 2nd grade whiskies and brandies, wines, spirits and liqueur. The same tax rate is applied to the liquors of the same quality, and there is no category where all imported products are subject to taxation. In fiscal year 1985, 83% of special grade, 99.9% of first grades and 100% of second grade whiskies and brandy taxed in Japan were Japanese products. As for labeling, Japan has enacted various legal regulations, such as the Law for the Prevention of Unfair Competition and the Act Against Unjustifiable Premiums and Misleading Representation. I shall now give the floor to Giorgio for the main arguments brought by the European Communities against Japan tax system.
According to the aggregate view of the European Communities, Japanese course of action was in all facts not in accordance with the Article 3, first and second section. The accusation revolved around the fact that the taxation system was over-articulated and complex. As a first point of concern, Japanese taxing system lacked uniformity. There was inequitable application of law on well-established product categories, where consequently imports were penalized. In fact, heavier taxes applied on imported products. The thorough approach followed by Japan, aimed at protecting products according to the EC, it curbed potential sales of imports in the alcoholic beverage industry. In other words, this conduct aggravated on import sales, on customers, and ultimately polluted the market. Going deeply into details, Japanese categorization was the first issue to be solved. As a matter of fact, fundamental distinction was made between Western-style beverages and traditional beverages. Consequently, traditional became somehow a synonymous of domestic, and by the fact that the domestic products fell under categories equal to similar competitive and substitutable products originating in the EC. An example of paramount importance is the one of vodka against shoku, whose content is almost the same but different in tax level were applied, although a really slight difference in content was present. Second issue to be solved was the grading system. Whiskies and brandies, for example, fell under three distinct categories: special grade, first and second grade. Again, there is room for discrimination here. Grading for these two liquors was mandatory, whereas sake could choose whether to apply grading and choose their way through the two alternatives of taxation. Not surprisingly, most community whiskies and brandies were marked as special grade with huge consequences onto the final customers. Due to this fact, EC argues that community whiskies and brandies were placed in an artificially luxury category and that more than a half domestic production enjoyed protection, being almost entirely of first and second grade, therefore a lower price. Some facts: imports first grade were 0.1% of the total first grade in the market, no second grade were there into the imports, and on top, 99% of the imports were special graded. The minimum tax rate on special grade was over 7 times higher than the tax rate on second grade whiskey, and again, to the EC, this was made on purpose. This brings us to the ultimate chain of this price building story, the so-called mix system, and especially the argument on the ad valorem tax. On most domestic products, the tax applied a specific tax rate, while for Western styles, specific applied just under a given price threshold. Otherwise, ad valorem would have applied. As a result, tax rates were therefore more than 8 times higher than the specific tax rate for what concerns wine, 4 times for liquors, and 2 times for spirits. You can all imagine that this gap results unfair. This also brought an unfair treatment in those segments where no fear of competition was plausible. The gap again is excessive. Also, for what concerned the calculation for the tax base, importers had to apply tax on CIF, customer insurance freight, plus the customer duty. On the other hand, local producers could choose between two alternatives, either manufacturer price or, when the final price was known, the price minus trade margin minus tax. Accusations from the EC rely on the fact that whiskies and brandies were locked out of the market, wine, spirits, and liqueurs respond to mixed taxation system, thereby prejudicing operation of import sales. Alcoholic beverages falling under extra content criteria were discriminated when compared with like products with slight different flavoring in sugar content. Further evidence are that the way tax categories were established was made arbitrarily and not on objective difference of the product. Difference in taxation could not be applied since domestic products were present in all categories. Moreover, substantial domestic production was in the lower tax rate and very high proportion of imported products were in the highly taxed regime. Drawing the attention to the Article 6 in its full meaning, this dynamics could, with no doubts, be detrimental to import activities concerning customer awareness, thereby impacting sales, with the ultimate effect of jeopardizing the market as a whole. Now I'll give the floor to Paolo, who will talk about the defendant, Japan.
Thank you, Giorgio. After the EEC claim, Japan requested the panel regarding the discrimination of the liquor tax and misinterpretation caused by labeling. Let's start with categorization. The tax categories did not make any distinction between domestic and imported products. Each category has been established by alcohol contents, quality, pattern, and trend of consumption. The aim was to balance the tax burden between different categories of liquors and of imposing higher tax rates on high quality. Regarding grading, the grading system was classified according to the objective standards. 83% of special grade whiskies taxed in 1985 had been domestic products. The ad valorem tax was meant to alleviate the retrogressive effect in indirect taxes and to ensure equity in tax burden sharing. Japan claimed that the ad valorem tax for imported products was simply derived, as Giuseppe said, through CIF and custom duty. However, for domestic product, the ad valorem tax required considerable work since the liquor tax had already been included in the price of transaction. Domestic product preferred deducting a fixed rate for the margin of the wholesalers and other distributors, transport charges, etc., from the retail price. Therefore, the tax base was the manufacturer's selling price. Regarding taxation according to tax continent, the Japanese market was composed of imported high and low quality liquors who were divided by 50-50 basis, and some 70% of quality liquors were domestic products. Bear in mind, the difference were in quality, content and use, so there was no direct competitiveness nor substitutability, let alone likeness. Even though imported liquors were less than 1% of Japan's liquor market, the share of imported products in whiskies and wine had been drastically increased since the liberalization of the imports. Japan did not agree on the EEC claim that the prices raised by high liquor were due to tax levied on EEC products. Consumers perceive imported goods as high quality. The tax burden rate to retail price for whiskey was lower for imported goods. Regarding the interpretations of the articles, the fourth section of Article 3 was interpreted according to 1948 Havana Conference. In fact, regulations and taxes would be permitted which are directed as much against the domestic production of another product of which there was a substantial domestic production as they are against import. It was meant to assist the production of a domestic product. While the second section was according to 1947 PrEP conference at Geneva, who was explained by this example. Let's suppose a country A has secured the binding of the duty on oranges from country B. If a country B put an internal duty on all oranges, seeing that it grows no oranges itself, the consequence is that the object of this binding is defeated, since the price of oranges is now so high that no one can buy them. Moreover, no precise definition of like products and the problems arising from the interpretation of this term should be examined on a case-by-case basis. In conclusion, regarding Article 9, Section 6, the labeling system in Japan consisted not only of self-imposed rules of the industry, but also of a range of additional legal controls described in the Japanese submission. Thus, the labeling of the alcoholic beverages was regulated not strictly than that of the other food products. Now, Silvia is going to talk about the panel's findings and conclusion.
According to the panel, in order to assess whether the Japanese taxes on imported wines and alcohol beverages was conform to Article 3, 1 and 2, it was necessary to make first a product comparison and a fiscal comparison. The product comparison had the aim to determine what products should be considered like products and directly competitive or substitutable products. In the article, there is no definition of like product, but every case should be assessed based on end uses, taste and habits, and products' properties, nature, and quality. Considering also that minor differences in taste, color, and other properties did not prevent products from qualifying as like products. The panel determined therefore 8 groups of like products, regardless whether they are domestic or imported ones. Moreover, considering that consumer habits vary in response of products' price and availability, the panel assessed as directly competitive or substitutable products distilled liqueurs, unsweetened and sweetened wines, and sparkling wines. After the products comparison, the fiscal comparison took place with the aim to determine whether discrimination occurred, and regarding this aspect, the panel stated that the prohibition of tax discrimination must be considered in a strict way. And so, even a very small tax differential amounting is forbidden. For whiskies and brandies, almost all the imports from the EEC were subject to the higher tax rates, whereas more than half of the domestic products benefited from considerably lower ones. And this differential taxation of like products is inconsistent with the Article 3, Paragraph 2. For wines, spirits and liqueurs, the use of a mixed system of specific and ad valorem taxes was permitted. However, since the ad valorem taxes were not applied to all the category, the result was a higher imposition on EEC products in respect to those applied to like domestic products. And this is as well in contrast with the article. Regarding the different methods of calculating ad valorem taxes for liquors, the panel concluded that adopting 2 different methods of calculation is allowed, and it did not dispose of enough evidences of tax discrimination caused by the use of this simplified method of tax calculation. Finally, for what concerns taxation, according to extract content of classic liqueurs and sparkling wines, the panel noted that the Article 3, Paragraph 2 does not prevent like products from being taxed in different ways, as long as this is not discriminatory. But also in this case, charges on domestic products resulted to be lower than those applied to like imported products, which typically had higher raw material contents, causing therefore discrimination. For all these matters, the Japanese argument of tax-bearing ability was not considered valid by the panel, as it did not justify discrimination and protectionism. The last issue examined was the one of the Japanese labeling practice, and regarding this matter, the panel argued that the EC did not provide clear evidences of the damage suffered by distinctive regional or geographical names, which was required by the Article 9, Paragraph 6. Considering all the previous examination, the conclusion of the panel was that the contracting parties should recommend that Japan brings taxes on whiskies, brandies, other distilled spirits, liqueurs, still wine, and sparkling wines in conformity with its obligation under the General Agreement. Now my colleague Chiara will talk about the following developments.
As required by the Article 21.3 of the Understanding on Rules and Procedures Governing the Settlement of Disputes, Japan informed the DSB on the 20th of November 1996 of its intentions in respect of the implementation of the DSB's recommendations and rulings. However, Japan stated that it wouldn't be able to implement immediately this new system, but only within a reasonable period of time without specifying it. It indicates that it would initiate negotiations with the European communities and the other parties to the disputes on what constitutes this period of time, but actually these negotiations did not succeed and no mutual agreements was reached. In January, in the absence of an agreement and after Japan and US failed to agree the appointment of an arbitrator, the United States requests that the Director General appoints an arbitrator. So the question for the arbitrator is, what is the shortest period of time in which implementation can take place? On the 20th of November 1997, it was agreed that all the original parties to the disputes could participate in the arbitration process. On the 21st of January, Japan formally adopted its proposal for a law to amend a portion of the liquor tax law and submitted it to the Diet for approval. The proposed amendments to the liquor tax law would be implemented within 23 months, considering it as a reasonable period of time because of particular circumstances justifying such a period that otherwise would have been of 15 months. With regard to Shokubi, the increase of tax would be implemented in 3 stages and within 5 years. Now let's have a look on what are these particular circumstances claimed by Japan. First of all, Japan invokes the limited power of the executive. Indeed, the proposed amendments involve drastic increases in the taxes on shochu, affecting both Japanese customers and shochu producers, and hence facing considerable political opposition and unpopularity. So the procedure for preparing and adopting these amendments will be difficult and complex. Secondly, under this tax reform, the tax on Sochu A will be increased by 1.6 times and that of Sochu B by 2.4 times. Japan argues that in order to mitigate the adverse impact, it is normal to spread these increases over time. Finally, Japan invokes the administrative constraints on the execution of taxation. These changes will have to be notified and explained to more than 180,000 wholesalers and retailers in advance, and this notification alone will take a huge amount of time. Nonetheless, all the complainants did not consider relevant the particular circumstances advanced by Japan. Japan tries again, and to compensate for the delayed implementation, offered the European communities, the US and Canada an accelerated reduction of the tariff rates on alcoholic beverages. On the 13th of February, the arbitrator concludes that a reasonable period of time for Japan is 15 months. Finally, we can consider in detail the case of the European community, and so let's have a look on the final agreement. Looking at the new tax rates, we can see the increase in 2 stages for Sochu A and in 3 stages for Sochu B, a decrease for whiskies of about 15.8% and a little increase in 1 stage for liquors. As for the new bond rates, the size of reduction for whiskey and brandy will be 48.7 per liter, and this is from October 1998 to March 2001, and 24.35 per liter for the next year.
In our opinion, Japan joined an organization with the main goal to expand and open international trade, but it exploited GATT directives and loopholes so as to build national competitive advantage in order to raise the barrier, thereby jeopardizing others' entrance in the sector. Alcohol beverages taxation was designed ad hoc with perhaps the ultimate purpose of building the edge vis-à-vis international competitors. This does not permit to middle and low classes to enjoy quality products, as it will be possible by being in line with WTO principles. As always, there are cultural obstacles on which much work still needs to be done. To conclude, panel has not still well defined the concept of trade name, which may well cause issues in future cases between the contracting parties. A clearer definition will be of high utility and avoid useless disputes. Thank you very much for your attention.